Okay, hello and welcome to this video capsule, which is designed to provide you with a solid introduction and a basic understanding of Section 13 of the Charter and the right against self-incrimination. This is part of my video capsule series that looks at the law of evidence, and this is a law of evidence that I don't particularly teach in my course, but I think it would be beneficial to a lot of people obviously studying in this area. So the easiest way to explain what Section 13 of the Charter does is look at its counterpart that you're probably familiar with if you watch any TV whatsoever. Because what you'll see on American TV all the time in a variety of different proceedings is you will hear people refuse to answer questions. And that is where this particular rule of evidence takes place. When somebody refuses to answer a question by saying, I wish to assert my Fifth Amendment privilege, which is essentially my privilege against self-incrimination. And one of the most famous of those took place in the O.J. Simpson case when Detective Mark Furman,
would you please resume?
Sorry about that, took the witness stand, and here's what happened. If you remember the case, obviously a very famous case, Detective Furman testified for the police. He was the primary investigator on the O.J. Simpson case. He said a lot of things. He was cross-examined about whether he had ever used racial epithets, and he denied doing so. The defense then uncovered evidence showing that he had in fact done so, so he was brought back to the witness stand for cross-examination. And here's what happened.
All right, good afternoon, Detective.
Good afternoon, Your Honor.
You're reminded, sir, that you were still under oath. Mr. Ullman, you may proceed.
Detective Furman, was the testimony that you gave in this case completely truthful?
I wish to assert my Fifth Amendment privilege.
Have you ever falsified a police report?
I wish to assert my Fifth Amendment privilege.
Is it your intention to assert your Fifth Amendment privilege with respect to all questions that I ask you?
Yes.
I only have one other question.
What was that, Mr. Ullman?
Detective Furman, did you plant or manufacture any evidence in this case?
I assert my Fifth Amendment privilege.
So essentially, he refused to answer any questions, and that was an important part of the case. Effectively, what happened in the case was the Crown was unable to rebut the allegations being made against Mr. Furman because he refused to answer anything. So it's worth exploring why he refused to answer and on what basis he refused to answer. And to do that, it's helpful to understand basic evidence law. So just give you a couple of basic rules of evidence law. They're helpful to know. First of all, any statement a person makes, and in this case we're talking about Mark Furman, and it's important to remember that Mark Furman is not the accused in the trial in which he's being questioned, right? He's just an ordinary witness, but any statement he makes can be used against him if he's going to be prosecuted in a future trial. Certain rules protect against these types of admissions, but they do not apply to statements made under oath. So when you are questioned in a criminal trial, or any trial for that matter, statements that you make in those trials would be admissible under the ordinary rules of evidence. So they're very probative, obviously. In this case, they would have probably exposed him as a perjurer. And, sorry about that went very fast, the Fifth Amendment protects people from having to make statements. So the basic idea of the Fifth Amendment is you cannot be forced to incriminate yourself. So you get to invoke the Fifth Amendment to protect yourself from having to make statements that can be used against you. Why? A very quick overview of the rationale for the privilege against self-incrimination. Like many rights, it emerged out of some wrongs. For example, the common law privilege against self-incrimination, which we're going to explore a bit later on, part of it came out of a fear of what was called the Star Chamber, a medieval court that had incredible powers and could force people to answer. It didn't think very much of due process, and if you look at privilege against self-incrimination cases even today, you'll hear the Star Chamber invoked. It was regarded by everyone as a very unfair process in which you could be convicted if you didn't answer and forced to answer in a variety of ways. An even more extreme example of this is the Spanish Inquisition, where people were tortured to answer. Again, forced to answer and denounced if they refused. So you were put in a terrible position of having to answer or deemed as to be a liar if you didn't. So the rationales for the privilege against self-incrimination, part of it is historical abuses. We don't like forcing people to testify against themselves. It's fundamentally unfair, if you think about it, to put the state in a position where it holds all the cards. If you cooperate and confess, you're guilty. If you don't, you're still guilty. And I should say that you may think, well, why should we protect guilty people? But it's not quite that simple. If you cooperate, you may say things that can be used against you even if you're not guilty and used to portray you as guilty. The basic rule of thumb is you don't want to provide statements because it's amazing how these can be manipulated to portray you as guilty. So don't think of the privilege against self-incrimination as just protecting guilty people. People have a fundamental right to be free of the state. If the state wants to allege criminality against you, which is a really serious power if you think about it in abstract terms, it should be forced to prove them. This is well established. The privilege against self-incrimination is very well entrenched in Canada as well. But just looking at the US to, again, understand what our Section 13 of the Charter actually does, it's important to recognize that the Fifth Amendment says essentially as follows: no person shall be compelled in a criminal case to be a witness against himself. And this is regarded as a very powerful protection. It's not read narrowly. What I mean is, if you look at that section, you look at the wording, you might think that it just protects you against being compelled in your own criminal trial, right, which would match up with Section 11C of the Charter of Rights and Freedoms in Canada. But that's not what it does. Witnesses are allowed under U.S. law to plead the Fifth. That's what Mr. Furman did to avoid being indirectly compelled to testify. And if you think about it, that makes perfect sense. If it otherwise, the protection would be completely diluted because you would have all sorts of ways of setting up separate proceedings to call the witness in which they're not particularly in jeopardy during that proceeding, but you then take the statement, which is now unprotected, and use it. So the Fifth Amendment protects against that use as well. And it does so in a very particular way. If you look at this one, you can see that a person cannot be compelled to testify at their own trial, but as you saw from the Furman example, you can be invoked to avoid making statement at any other trial. And if you look through YouTube or Google Fifth Amendment, you'll see it's invoked in a variety of proceedings: civil hearings, congressional inquiries. Anytime you are asked to make a statement that has the potential you can only answer it by invoking some form of criminality, you can invoke the privilege against self-incrimination and say, I'm not going to answer that because it would force me to incriminate myself. So if you look at the protection under the Fifth Amendment, you have this situation where we want your statement. It's helpful to think of this outside of the situation of your own trial. What I mean by that is, think about the Mark Furman example again. He was not on trial when he was being asked for his statement, but they were trying to investigate the allegations against O.J. Simpson, and we wanted to test his credibility by really exploring the nature of what he knew, whether he had fabricated evidence, etc. So they say, we want your statement, but the Constitution says you're not getting one. It stands in the way. And I call this front-end protection. And the reason I call it front-end protection is it protects the right to self-incrimination or right against self-incrimination by stopping a statement from ever being made. So it means you never produce the statement. Mark Furman never had to say anything. But to be clear, Fifth Amendment protection ends if you make a statement voluntarily. Once that statement is made, it can be used for anything. So if you get up in another trial and say, I'm not aware of my Fifth Amendment right, I'm just going to testify, that statement can be used for anything. That's what I call front-end protection. It stops statements from being made. But the result of the Fifth Amendment is very severe. On one hand, the person's right against self-incrimination is protected. Mark Furman didn't have to make a statement in the O.J. Simpson trial. But valuable evidence is lost in the trial where you're trying to get the statement. What I mean by this is, in the People versus O.J. Simpson, Furman protects himself by invoking the Fifth Amendment. But there are losers in this as well. The winner is O.J. Simpson, if you think about it, because he's allowed to cast allegations that Furman was lying, Furman was manufacturing evidence. It may or may not have been true. We couldn't explore the allegation. And you can argue that the loser is justice. And I think there's a strong argument to be made that that's the problem with the Fifth Amendment. Justice loses because we are unable to explore allegations fully. We just can't do it. Think about a congressional inquiry. Let's say the Congress is investigating Enron and it wants to see what's going on. It's trying to sort out, for example, a problem in the stock market. But the Enron directors are worried about their own criminality. So as soon as they start getting questions about their business practice, they invoke the privilege against self-incrimination. And that stops the discussion. You cannot get the evidence for something that has really nothing to do with their own criminality, solely because the privilege the U.S. Constitution protects is what's called front-end protection. And as you'll see in a moment, that's not how Canada works. And the Canadian approach has benefits and some detriments that the U.S. Constitution doesn't. So, to recap very briefly, privilege against self-incrimination is important. We need to protect it one way or another. And the Fifth Amendment does that through front-end protection. It operates at the expense of the truth. I hope everybody recognizes that. The downside of the U.S. Amendment is you cannot explore the truth in a proceeding if it's going to expose another person's criminality and they invoke the privilege. Sometimes it's necessary to explore what A, think of A being Furman, did wrong in order to find out the truth about B, O.J. Simpson. And the Fifth Amendment operates across the board. In any judicial proceeding, you can invoke it if there's a valid concern about self-incrimination. Okay. What about in Canada? Now, prior to the enactment of the Charter, which I'm going to come to discuss, Canada recognized the long-held importance of the privilege against self-incrimination. So the witness had a common law privilege that if you look at what I've just set out there, right, this is exactly like the U.S. position. The witness has a privilege at common law to say, I am not going to answer, because I don't want to produce a statement where it would incriminate me. And by the way, I should just stress, the witness only has this privilege in another trial. What I mean by that is, let's say the accused is on trial. Let's say A is on trial for murder in his own trial. Once A takes the stand in his own defense, he cannot invoke the privilege against self-incrimination. As you could think about it, it would be nonsensical. You essentially waive the privilege against self-incrimination when you testify at your own trial. But in other trials, you have that common law privilege. So if Mark Furman was called in Canada at the fictional trial of O.J. Simpson, he would be in no different position at common law. But the common law no longer dominates in Canada. And the reason is that Canadians didn't like the U.S. position, so evidence legislation in every jurisdiction removed it. And here's how. The Canada Evidence Act is a good example of how this takes place. Section 5.1 of the Canada Evidence Act says that no witness shall be excused from answering any question on the ground that the answer may tend to incriminate themselves. However, here's the key. They provide protection in a different way. They have to answer the question. It says so right here. You are compelled to answer, but the answer shall not be used or admissible in evidence against him in any criminal trial. Very, very important. This is, as I will show you, a form of what I call back-end protection. Here's what I mean. Here's front-end protection. The Constitution stops the statement, but the protection ends the moment the statement is made. Well, Canada's law doesn't work that way. Instead, it provides back-end protection. We want your statement, no problem. Section 5.1 says you can force the witness to answer. But the back-end protection is, once the statement is out in the world, it cannot be used for incriminating purposes. And I'm going to show you that that has some advantages. It actually has a lot of advantages, but it also has some disadvantages, and we'll go through them in some detail. But first of all, I haven't even brought in the Charter yet. So here it is. Section 13 says something more or less along the lines of the Canada Evidence Act, but it says a few different things. A witness who testifies in any proceedings, and look at that wording, has the right not to have any incriminating evidence used to incriminate that witness in other proceedings, except in a prosecution for perjury or the giving of contradictory evidence. You might wonder, why shouldn't we just rely on evidence legislation? Why did we enact the Charter? Truth of the matter is, the Charter, for most purposes, is a much stronger form of protection than Section 5 of the Canada Evidence Act. Number one, evidence law requires witnesses to object. And I think that's a terrible thing because, frankly, most of the time witnesses are unaware of the need to object unless they have counsel. And they don't even know. It's much better to have the protection in place so they don't require legal advice. It's just there. It's there all the time, whether they object or not. 2. Canadians we have a constitutional jurisdiction that splits up between provinces and the federal government. And the truth of the matter is, for this to work, you need to have every province and territory have the same law. Really, because if you think about it, let's say I'm in British Columbia and there's a civil proceeding and they force me to answer a question. Well, if they don't have a law that protects my privilege against self-incrimination, if I say something incriminating, they could use that. The federal government could then try to use that evidence against me. Now, the Canada Evidence Act might prevent that from happening because it would be useful in the particular jurisdiction. It would be useful in every jurisdiction in a criminal proceeding. But the truth of the matter is, you need both jurisdictions to set up the same sort of law, or everything sort of gets messed up. They need to be working in concert together. And the Charter is just much better at that. It works across the board. It has effectively superseded all federal and provincial legislation. And finally, remember that the Canada Evidence Act could be repealed or altered. It's not a constitutional guarantee. So it's really important, I think, to have the Charter, and that's why it is the most important aspect of the privilege against self-incrimination. So I want to look at it, and I'm going to show you how it works. I'm going to show you its strong points and its weak points, and in doing so, I'm going to focus on 4 things. 1, I'll look very quickly at the exception to Section 13. Second, I'll look at what is protected and, frankly, what's not protected, and you'll start to see where some of the concerns are. I'll look very briefly at the type of proceedings that incriminate you, and then we'll talk about whether evidence can be used for non-incriminating purposes without violating Section 13. I would argue that that's the most controversial aspect of Section 13. The exception, straightforward. I've got Pinocchio because we don't protect liars. Section 13 makes very clear that if you lie, that can be used against you in a prosecution for perjury. And if you think about it, it has to be this way. If you didn't have this exception, anytime somebody says something that's a complete lie in another proceeding, you couldn't use it against them in a perjury proceeding. You need the exception because obviously the evidence is being used to incriminate. So we don't allow that to take place. You can always prosecute someone because of what they testified to in a proceeding. So let's move on. What is protected? Well, to first start with, we have to decide what type of evidence is actually covered, because it only applies to everyone who testifies in a proceeding, and the word proceeding is not defined. And I've got a little picture over here about police because I'm not kidding. Somebody in the early days tried to say, well, interviews with police are formal, they're recorded, they're just like proceedings. Well, think what that would mean if Section 13 applied to this type of evidence. If you had an interview with the police, which they do all the time with suspects, it would be banned from court by Section 13. And let's just say that the courts dismiss this very quickly. No, an interview with the police is not formal enough to be a proceeding. But what we do know is testifying in a proceeding is taken pretty broadly. You don't actually have to physically testify in open court. Affidavits are effectively testifying. They are sworn testimony that is being adduced into a proceeding. So they count and they are protected by Section 13. The trickiest area of law I've set out right over here is about administrative hearings. Those are a really interesting area that hasn't been fully explored, mainly because there's so little case law on this. And administrative hearings are kind of interesting because a lot of time they're not quite the same thing as court cases. So we know that if you testify in a criminal trial, protected. Civil trial, protected. Family court hearing, protected. Doesn't matter. But administrative hearings are a little bit broader than that, right? We have informal situations where you may give a statement, and the question is, if you reveal criminality in that statement, is it protected? The answer, by and large, is yes. Most of the time, so long as there is some sort of formal structure, I argue that should be the focus, and I argue you should look at whether there are penalties for failing to testify. I mean, if it's essentially akin to a procedure where you get subpoenaed or pulled in, then it's formal enough to qualify as a proceeding. I'm not sure everything short of that, where you're having informal discussions as part of an authorized procedure, should qualify, but the case law just hasn't looked at this closely enough to try and come up with some overview. So let's go with the fact that administrative hearings are, in fact, proceedings. Here's the interesting thing. On the other side of the equation, what type of proceedings can incriminate? Because if you look at the way Section 13 is worded, what it says is you cannot have testimony used to incriminate you in another proceeding. And what the courts have held is if the use that's being sought for the statement is not incriminating, Section 13 does not apply. Now be very careful here what I'm about to say. There may be protections under other parts of the Charter for what I'm about to discuss, but let's be clear that Section 13, according to the jurisprudence as it now stands, does not apply to these things. So, for example, sentencing. It's been held that Section 13 does not prevent the use of a prior statement made in a judicial proceeding if it's only being used to sentence you, on the basis that the right against self-incrimination ends at sentencing. You've already been found guilty. Now, I'm not sure that jurisprudence is necessarily correct, but that's where it stands right now. Section 13 will not stop a prior statement from being used against you. Here's another interesting one. A search warrant. Well, a search warrant application is trying to discover evidence, but it is not incriminating, and therefore, Section 13 does not prevent the prior use of such a statement. Now, there is good reason to believe other sections of the Charter might have issue with judicial, evidence you gave as testimony being used against you, but not by Section 13. And finally, one that's very clear is disciplinary hearings. So let's say you have a lawyer who is called to testify in a criminal case, and they say something that's very incriminatory. It says they were, they breached trust or they committed a fraud, right? Well, that evidence cannot be brought against them for a criminal hearing. But a disciplinary hearing, no problem. You are not being incriminated against. It is not that type of penal proceeding. You can be stripped of your license using evidence that was compelled from you in a court of law. It just does not apply as the jurisprudence now stands. Now let's look at the biggest controversy, because I think this also illuminates some of the potential shortcomings of Section 13. We've just looked at some of the uses of incriminate, but it's not the most complicated. Does cross-examination to impeach incriminate? And this has caused the jurisprudence a lot of problems in Canada. And I'll show you where this becomes an issue. So let's say we have our two witnesses again. Trial A, which is charging Bob. So Bob's on trial. Here, Johnny's called as a defense witness. And Johnny gets up and says, Bob didn't rob a bank, I did. Okay, no problem. Can we use that statement against Johnny? He's now effectively confessed. Can we use that very statement to prosecute him for the robbery? No, we cannot. Section 13 prevents any use during the Crown case. That's absolutely clear. So, but what happens if Johnny gets up and in his trial says it was Bob? So now reversing his story. So what he's got now are two different stories. Well, the prosecutor wants to use the statement not to incriminate him, but to show that he is a liar. Does this violate Section 13 of the Charter? Well, let's just say that the jurisprudence has not been uniform on this point. The Supreme Court's gone all over the place on this. From 1990 to 2002, they held you could impeach. Justice Lemaire, writing in a decision called Culdip, says it is not incriminating to impeach. They are two different things. Until 2002. Justice Arbour, writing in a case called Noel, says it is totally incriminating to impeach. Essentially, Justice Arbour said there's no real difference between the two. Showing that somebody is a liar ultimately makes them much more likely to be convicted. It is incriminating. In 2013, we had a case called Nedelcu, a decision I'm not very fond of, in which Justice Moldaver more or less applied the Arbour approach, saying that it's the same thing. But they drew a distinction between the type of testimony that was taken at first instance. They said in some circumstances where witnesses give evidence that is not in any way incriminating, you can use it essentially for all purposes, but especially to impeach. And if that's confusing to you, well, Nedelcu is a pretty confusing case that's based on some troublesome distinctions, but I'll explain to you what it means. What happened in Nedelcu was you had a witness who gets up on the stand the first time, right? And essentially says stuff like, I don't know, I have no recollection, this never happened, I wasn't there. It doesn't really matter what he said, but effectively what you have to think about is what he said at first instance was totally not, according to the Supreme Court, incriminating. You can't prosecute a guy for saying I wasn't there, or I don't remember. But then when he got up at his criminal trial and testified, he said different things. He said things like, I do remember, right? Or I remember, but I didn't do it. And then the Crown wanted to use the prior statement to impeach, and the court said he could, for the reason that the testimony, when it was given, was not incriminatory. Now, very briefly, I do not like this decision. I think it's very complex. I think it draws distinctions that are inappropriate because I think you have to start thinking about the nature of the testimony that's given at first instance. And frankly, to me, I don't think that's the concern. It's not whether it was incriminatory when it was first taken. The real issue is the use that it's put to at the second trial. But nonetheless, that's what the Supreme Court says we must do. We must look at that first testimony and decide whether it's incriminating. The result from all these cases is that a person can lie under oath and the prosecution cannot impeach them. Everybody got that? That's really important. So when you have this first case with Johnny over here, and he gets up and says, Bob didn't rob the bank, I did, and then gets up at his own trial and says something totally different, well, you can use those statements to prosecute him for perjury if you want, but you cannot impeach him at his criminal trial. Section 13 prevents against that use. Frankly, that's what drives the courts crazy. It drives them crazy because what you have is essentially that Section 13 allows people to lie in a certain way, or exaggerate, or fabricate, or whatever you want to call it, on the witness stand. But to be honest, that's what Section 13 does. Section 13 is a compromise. It is a compromise that allows us to extract evidence from you, not necessarily good evidence, but you cannot refuse to testify. You have to give evidence that we need, but we can then use it. We can't use it against you. In effect, that's the bargain. And the bargain leads to some ugly cases here and there. But in my opinion, better than having someone get up on the stand and say, I'm not going to answer. You cannot explore this at all because you could use that against me. There's one last question which the Supreme Court has not addressed. They talk a lot in these cases about what's called the quid pro quo. The bargain is that if I force you to testify, you will be protected. And there has been some hinting in the jurisprudence that if you're not forced, in other words, if you testify voluntarily, then you're not protected by Section 13. Let's just say that for the moment, the Supreme Court is seeming to hold firm on the idea that it doesn't matter if you testify voluntarily or not, and frankly, I think that's great. I think it really shouldn't matter whether you testify voluntarily or not because it's very difficult to find out if you actually testified voluntarily or not. It requires people to issue subpoenas just to be clear, to be sure that you're testifying against your will. It's just not an inquiry I think we should get into. Effectively, the only people who testify and don't get the protection are when you testify at your own criminal trial. As I said, that waives the privilege by taking the act of testifying on your trial. So just to point out, this controversy about what it means to incriminate stems from a real concern. That you have to remember that the bargain of Section 13 is that some people are getting to make self-serving confessions and they can't be prosecuted for them, except for perjury. It allows people to lie secure in the knowledge that the lies cannot be used against them unless you can somehow manage to get a perjury prosecution, and that won't always be possible. I guess my question is this really a major concern? It seems like one in the abstract when you have a case in which people are lying and you can't do anything about it, but frankly, when you look at the big picture, think about what Section 13 allows us to gain. It allows us to do proper inquiries into any potential case, and that's a really beneficial thing. So, to recap, Section 13 has enormous benefits. The truth is never hidden by the right to remain silent. But it also has drawbacks. In some cases, people will go free despite having confessed to the crime in another proceeding. That's the quid pro quo exchange. The state always gets your evidence but cannot use it against you. Now, some of you watching this capsule may have thought about one little aspect of this, which I'll just leave as a last parting thought for you to think about. Section 13 protects people from the use of their testimony, but the word is very clear. The testimony is what's protected. What about the guy who gets forced to testify by the Crown and during the course of that testimony is cross-examined, right? It's not his trial, and reveals evidence, like he's forced to question about a gun that he had and he has to tell the Crown where that gun was hidden. Is the gun then protected from the proceedings? Well, the answer to that question is yes and no. Section 13 does not protect that gun. If there is any protection at all, it is through a different doctrine, one called derivative use immunity under Section 7 of the Charter, and something that I will explore in a subsequent capsule because it's an important evidentiary doctrine. But nonetheless, for the purposes of this podcast for Section 13, we are looking solely at the protection of the testimony and statements made on the witness stand. And that's pretty much all you need to know to have a basic understanding of Section 13. You understand why it's different from pleading the Fifth Amendment, why it's beneficial, some of the drawbacks, and how it actually operates. In any event, I hope that was useful to you, and have a great day.